Good afternoon. This is George Yates, and I'm here with Justice for All. I'll be your host for the next 2 hours, and I'm really excited today. I'm really thrilled that I've got my guest here is gone international. His name is Harvey McGregor, and he's on the line with us from the United Kingdom. He is the author of the definitive civil damages book in the UK. It's now available on Amazon. I think it's a $900 book, so you can rush out and buy that book. Those of you who are interested in civil damages, Harvey McGregor is in the who's who of the United Kingdom. He's a commander of the British Empire. He is one of the premier barristers in all of the United Kingdom and in Scotland. He is a Queen's Counsel, and he is on the line with us today. How are you, Mr. McGregor?
I'm well, thank you.
I'm really excited. I had an opportunity to Skype with Mr. McGregor earlier this week, and this book that you've just come out with, civil damages book, it is, I think he's breathing in. Mr. McGregor.
Yes.
Can you get back from the phone just a little bit there? I think we're hearing some breathing coming into the phone line. Okay, that's much better. Much better. How are you doing today?
I'm doing all right. I'm just waiting for your questions.
Okay. Sir, I noticed that you were born in 1926, and that
yes,
makes
I'm very old.
Oh, well, what is that? I'd love to talk about your life a little bit. You came of age, I guess, during World War II. Can you tell us about that?
Well, yes, I came of age. In 1944, I was 18 and went into the Royal Air Force, and I was in the Air Force for 4 years. I was hoping to be what they call a boy in blue and be a pilot or a navigator, but I was accepted for that in February of the year, and then when it came to D-Day in June, they decided they didn't want to have, commission anymore or bring any more pilots and navigators in. So they offered me some rather dull jobs at the lowest level, of course. I was only 18. But then I discovered they had language courses. And I thought if I had a language course, that would keep the brain functioning. And they had them both for the enemy and the ally. And they were, in other words, German, Russian, Chinese, and Japanese. They were discontinuing the European ones because, again, the war was looking to be at an end after D-Day, which was the case. And so I had to choose between Japanese and Chinese, and I chose Chinese. I looked into it, and if you learned the language of the enemy, you had a short, sharp course, probably lasted for 3 months, and then you were, as I put it, dropped behind the lines and probably shot. But if you had the language of the ally, in this case Chinese, you had an 18-month course at the best schools in London, and it's called the School of Oriental and African Studies, and so that you could be interesting and amusing at cocktail parties at the embassy. So I had 18 months of Mandarin Chinese. I became quite an expert, and I've forgotten it all by now, because that was, after all, 70 years ago.
What a fascinating...
So that's the story.
So you went to... did you go from there to college?
Yes, I was sent out to Singapore. Somebody who was given the job of sending people out after they'd finished their courses who didn't know much about Chinese. He would have said, "Oh, these chaps know Chinese. We'll send them to Singapore." Well, of course, in Singapore they don't talk Mandarin Chinese, but Cantonese, which is an entirely different language, effectively. So I never used the Chinese in the Far East. But after a year and a bit, I was demobilized, and I came back, and I went straight to Oxford, where I had a scholarship, and therefore they would accept me the moment I got back.
Well, now you are...
And in those days, because people got demobilized at all times of the year, you didn't have to wait till the beginning of the next academic year before you went to the university. So you could go at the beginning of any term. So I arrived in January 1948. I was demobilized at the beginning of January, and within a week I was in Oxford.
Now, where is Oxford? That's in England?
Sorry?
Where is Oxford located?
What is it? Where is Oxford located?
Yes.
Oh, it's in the south of England. With Cambridge, they're the two oldest universities in this country. The Oxford dates back to the 1250s. So we're talking about nearly 800 years. That's very old.
Now, when you go to Oxford, it's a 4-year degree. Is it the same as America? You get a 4-year degree and you get a bachelor's?
No, you take a 3-year degree, and then you become a bachelor of, well, it's called a Bachelor of Arts rather than a Bachelor of Law. And we get a Bachelor of Arts, whatever subject you're doing, whether it's law or science or French or whatever. So I got my Bachelor of Arts 3 years later.
And that was from Oxford?
Well, from Oxford, I was lucky enough to, I had a splendid tutor, a man called Zelman Cowan. He wasn't my tutor at my college, but at another college, and I'd been farmed out to him. And he was obviously impressed by my legal skills as they were becoming, because it's very difficult to decide about reading law, because you've never done it at school, and it's a leap in the dark. Anyhow, I turned out to be good at it, and so one day he called me and said, "How would you like a job in America?" And he managed to get me a job teaching at the University of Chicago for a year. And I got this job even before I had taken my degree exams in Oxford. And when I got there, I had a splendid year in Chicago. And of course, I was only 23, 24, so some of the students were older than me.
Yeah, I noticed that you've taught at the University of Chicago, you've taught at Rutgers, you've taught at NYU, and at Harvard. And you have
I haven't taught at Harvard. I just got Harvard's highest law degree.
Then when did you obtain that?
Well, I suppose I was there in 1953-54, which is 60 years ago, and I obtained the degree about 5-6 years later, because you had to produce a thesis and submit it.
I have your book here. It's called. It's just called Damages. McGregor on Damages.
It's called McGregor on Damages.
McGregor
yes.
on Damages. Now, I noticed.
It's a very beautiful book.
It is, and I appreciate you providing me with a copy of this. I imagine.
Yes, because it costs about, as you said, $900.
This book, I noticed in the beginning of this book, the first edition came out. Mr. McGregor, would you please sit back a little bit from the microphone of your phone, because it's distorting, your breath is coming through. There you go. Thank you. That's much better.
Is that all right?
Yeah, that's much better. Thank you.
I see.
Okay. I noticed the first edition of your book came out in 1856 by John Maine, And then there was a second edition in 1872 by Lumley Smith. And they continued to update this damages book all the way up until when you took it over. Let's see. Then someone else took it over in the ninth edition. And you began in 1961, I think, with your first edition of the book, but that would be the 12th edition in 1961. And now,
that's right.
This latest edition is the 19th edition, just published this year, and it's dedicated to your mother and father, and it's McGregor on damages. You are the authority then in the United Kingdom on damages. I guess that's fair to say.
Yes, not only the United Kingdom, but Australia, Canada, New Zealand, even Japan reads the book, and Israel. The book is world famous.
Well, tell me a little bit. What are damages? Define damages for those people listening who don't know about the civil law.
Well, it means if you've got a contract and you break the contract, you can be sued for damages, for loss of profits, or sale of goods. If it's a sale of land, employment contracts, if you break them, or construction contracts, and then there's, apart from contract law, there are books, big books on contract, and this is the damages end of it. And we have also what we call tort. I think it's called tort also in the States. It just means a wrong, and it means if you negligently knock somebody down in your motor car, or you libel him, all sorts of, or you pinch his copyright, then all of that is a tort, and you've got to decide what loss was suffered by. The damages basically are a compensation for loss resulting from a breach of contract or a tort.
And when you talk about what damages are, that's going to vary then from the type of case it is, and whether it's contract or tort. What about costs as far as somebody suing somebody? Are they also entitled as their damages to get their costs, their attorney's fees, that sort of thing?
Well, the general rule has been that if you succeed in your case, and you're the claimant, the defendant has to pay your costs, and not only your costs, but you don't have to pay his costs, which is very different from the American situation. But that makes sense.
If you sue, and if you're the plaintiff and you sue and you lose your case, are you required to pay the defendant's costs?
Yes.
What if you have a plaintiff?
That's the way it normally works. In other words, the winner has his costs paid. Not only his costs paid, but he has the... so if the winner is the plaintiff, we now call the plaintiff the claimant. We called him the plaintiff up till about 20 years ago, and then they thought claimant was a more user-friendly word that people outside the law would more easily understand than plaintiff. So in Scotland, in fact, they have another word for plaintiff claimant, which is a rather amusing one. He's called the pursuer, but you're running after somebody.
But what if the plaintiff doesn't have any money? What if you have a poor plaintiff, let's say, that's injured in a...
Well, we have a legal aid in this country, and you can be entitled to legal aid. I mean, it's all rather changing recently, but I can't go into all those details. But generally speaking, you have legal aid, and also, if it's a very good case and your lawyer thinks it's a very good case, he can be sure that his costs will be paid by the other side, by the losing defendant.
And does he bill that by the hour? He keeps a hourly track and then submits his bill at the end of the case?
Yeah, I think that's how they do it. And would do it that way, yes. Can I just go back to the question about writing the book? It started in 1856, as you say.
Yes.
And it was written by Maine, and it was one of the earliest books written on the law, really modern books on the law, and they started in the second half of the 19th century. And it was edited by, as you pointed out, by various people over the years for 100 years. And I was asked to edit it in the you say 1961, but that, of course, is when the book came out. I started work on it a few years earlier because there was a lot to do, like 1956-7. But I was just asked to edit the book, and I well, it's a slightly longer story than this, but I needn't go into all of that. Well, perhaps I can. I've been to Harvard and had to write a thesis to get my doctorate, which I may say is a doctorate which they very seldom award, the Doctor of Juridical Science, it's called. And I was going to write a book on a subject called restitution, which you don't have to know about, because there seemed to be a whole window in the market for that. But when I came back to England, I didn't find that anyone would publish it because they already had people doing it. So when I was offered damages, I thought, well, I'll take that up, because I didn't want to write a thesis and then just put it in a drawer. And so I was given the editorship of it, but it turned out the book was so bad. I mean, it had been good when it was written in 1856, but all the various editors had just put the new stuff into footnotes and walked away with their money. And so I said, I'll have to rewrite it. So I did rewrite it. Right, I only kept the first sentence. And so the publisher was very good in allowing me to do that. So I said to them, if I've written it, shouldn't you call it after me? And they said, call it after you, no one's ever heard of you. And so they wanted to keep the name of Maine. And so I made the agreement with them that the first edition would be called Maine and McGregor, and that would get my name onto the legal people would know it. And if it was successful, which of course I'm glad to say it was, the next edition would just be called McGregor. So I thought you'd find that interesting.
Well, that is. I'm here on 1650 AM. This is Justice for All. I'm George Yates, your host, and I'm here with Harvey McGregor, who is a Queen's Counsel barrister from England, and he is the author of the 19th edition of McGregor on Damages, and we're discussing his book on damages. When you wrote your first edition in 1961, you say it was pretty successful.
It was very successful, if I may say so.
And at that time, were you a barrister, a practicing barrister at that time?
Yes, I was practicing. I was, yes.
And tell us a little bit about what a barrister is, as opposed to a lawyer in America.
Well, we've got two types of lawyer. One's called a barrister, and the other's called a solicitor. Both of them are lawyers. Lawyers is a generic term, and the barrister effectively is the court man, and the solicitor is the one behind the scenes. The solicitor is in a firm of other solicitors with partners, and a client with a problem goes to a solicitor. Now, a solicitor may be able to deal with this problem. If all he wants to do is write a will, well, that's not a problem. If he wants to transfer some real estate, that can be done by the solicitor. But if there is an issue, if there's an argument and somebody is likely to be sued or sue you, for instance, take a simple case, you have a road traffic accident and you're run down and you want to sue the car driver. Of course, his insurance company will pay, but nevertheless, you would then, the solicitor might then take that to the barrister, and he would come to a view as to whether you had a good case. You only have a good case if the person was negligent, and he may not have been negligent, even though you have been run down. And also, there will be the question of the damages. How would you assess the damages? Little too difficult for a solicitor to do. So the barrister gets the job, and he will write an opinion generally, and it may be that the case can be settled. Lots of cases are settled these days. More cases are settled because costs are so high. But if it isn't settled, then the barrister will argue it in court. And that's effectively what barristers do. Another distinction between solicitors and barristers, and I'm sure you have the same in America. You've got lawyers that are trial lawyers, and you've got lawyers that aren't trial lawyers. Is that the solicitors, they're all within firms and companies and are partners, whereas barristers are self-employed individuals. They're not in partnership with each other. But what happens is that a group of barristers will get together and from senior to junior, and will take premises in the legal area. They're called the Inns of Court. There are 4 Inns of Court. You may have heard of them: the Inner Temple, the Middle Temple, Lincoln's Inn, and Gray's Inn. And they're full of. It's a lovely part of London. It's old world buildings, screened off from the main streets. Once you're into them, you'd think you weren't in a big city at all. And all that you take premises. The group takes premises which are always referred to as chambers. So I'm in chambers, and they're called Hailsham chambers. That was because the Lord Chancellor was once called Hailsham, and he had been a member of the chambers some 30, 40 years ago. And so being self-employed and being not in partnership, no, you're not responsible for anybody else's work. You are the sole person who can be sued for negligence, if you were, and the other members of chambers wouldn't be affected. You pay, of course, all the expenses of chambers. The reason you take the premises is so that you've got premises which will take, which will be available for solicitors coming for conferences. We have a number of conference rooms, and we split up the expenses, which now are very high. I think ours are something like $1 million a year, but I'm not sure exactly. But you build the expenses. You charge the members of chambers according to the money is coming into them. In other words, if you get 100,000, you pay more than the person who is only getting 10,000, 10 times as much. And also, there's an amenity factor normally put in. Certainly, it is in our chambers. If you've got a lovely room, you may have to pay more than someone who's got a smaller room. And many of us share rooms. It's very common. I share a room with 2 others. It's a very beautiful, large room.
We are here with...
So does that help?
Yes, we are here with Harvey McGregor. He's a Queen's Counsel barrister from the United Kingdom. He is the author of the definitive book on damages around the world in the Commonwealth nations, McGregor on Damages. This is George Yates. I'm here with Justice for All. We're going to take a short break, and we're going to be back for the rest of our interview with Harvey McGregor.
Fink's Car Care, with locations in Chesapeake and Portsmouth, is your dedicated Tire Stars dealer. At Fink's, their experienced staff specializes in brakes, steering, suspension, tune-ups, oil changes, and much more. They also handle rebuilt engines and transmissions, and they're your destination for tires, rims, and towing as well. Fink's is located at 2236 South Military Highway at 2711 Victory Boulevard. For more information, log on to finkscarcare.com or call 545-3573.
The reason why our country is in the trouble that it's in is because our pulpits have gone neutral. That is the job. Right now, our pulpits are so afraid to shine the light into true darkness, they won't do it. What do you say we put our pen lights down and we grab a spotlight and we start looking where real darkness is and we start putting light where darkness is?
Glenn Beck, weekdays, 3 to 6 p.m. on K-Talk 1650.
For the very best in down-home music, join us on Saturdays, 11 a.m. for Ramblin' Ralph's Bluegrass Special with the authority on bluegrass music, Ralph Coleman. Saturdays at 11 a.m. on AM 1650 WHKT. Ramblin' Ralph's Bluegrass Special.
We are back with Harvey McGregor. I'm George Yates. I'm the host of Justice for All. And Harvey McGregor is a commander of the British Empire. Harvey, when were you bestowed that honor? What is it? And tell us about your titles.
Well, it's quite a high title. It's the one just short of being a knight, being Sir someone. We have... These were set up by George V about 1912. There's the Order of the British Empire, the Member of the British Empire, and the Commander. These are in order of, in advancing order. So a C.B.E. is quite an important honor, and that was granted. The Queen has honours lists that are produced twice a year. There's the New Year's honours list at obviously New Year, and there's also one in June on the Queen's birthday. It's not actually the Queen's birthday because she was born in April, but they always say that it's the birthday of the monarch is in June. I appeared in the New Year's honours list of this year. As many people said, you should have got this many years ago, but better late than never, you might say. And you have an investiture with the Queen, and that is normally done at Buckingham Palace. And I had many, many letters saying how wonderful it was that I'd got this great honor, and various people had lunches. I'm connected with Edinburgh University because I do a little legal work there, and the head of the university had a lunch for the people that were in the honors list, of which I think there were 5 or 6. And one lady said, "I have got my date for my investiture," I said, "Well, I hadn't heard anything about mine," and but she said they've decided what all the dates are. So I phoned up Buckingham Palace and the following morning and said, "What is my date?" And she said, "July the 1st." And I thought that was rather long ahead because it was still only in March. And I said, well, no doubt you'll be letting me know when to come down to Buckingham Palace. She said, oh, no, it's not at Buckingham Palace. It's in Holyrood Palace in Edinburgh, which is much more beautiful and much nicer. And the Queen likes to do all Scots people when she visits Edinburgh, which she never does until the beginning of July. And the result is you have the investiture by the Queen, where some people only get the Duke of Edinburgh or Prince Charles. And so on July the 1st, on a beautiful day, there were 60 of us getting invested. The room is full of, you're allowed 3 guests. It's a beautiful palace. And the Queen is there, and you come up in a one by one, and you approach the Queen, and you bow, and she puts your the ribbon round your head, which has the medal on it, the C.B.E. medal, and then she has a few words with you, and then you move on. And so people said to me, and what did the Queen say to you? And I said, I'm afraid I can't remember. I did most of the talking.
And this is for your contributions to the British Empire through your legal work, through the public
through law. It was given as through law and education.
Because you have been you've been a professor, then a teacher of the law for many years.
Yes, and I was also the head of an Oxford college, which is not something that which is quite a high position to have. I was called the warden of New College. Now it's called New College, but it's actually 700 years old, or not quite 700, but 600, I think.
Well, I want you to know, Harvey, that today when I did a little research on you and I went through your Wikipedia, the dictionary entry for Harvey McGregor under Wikipedia, they had on your site that your edition of your damages book was 2009. So I want you to know that I went onto Wikipedia today and I edited your Wikipedia dictionary entry to show that you have just published your 19th edition, and it just came out in 2014. So I'm doing my best.
Wikipedia is now up to date.
Wikipedia, at least as far as that goes. I went through your entry. I said, they do not have his new book here on the references section of it, so I want you to know I updated it for you.
Well, it's only been out for a month and a half.
Well, somebody had to do it, and that's me.
Yes, well, very good of you. Thank you very much.
Now, you were the head of Oxford College. That is quite an honor. What years did you do that?
That was 85 to 96. I was 59 when I was elected, and they have a retirement age of 70. So I had to go at nearly 20 years ago now. The great advantage of being a barrister is you don't have to retire. If you're self-employed, you can go on as long as you like, as I am doing. Of course, you get a bit less work because people think that you probably have retired or probably died, but not me. And so I did the headship of the college for those 11 years and was a barrister in London at the same time.
I got
and people said, well, how did you do it? I said, because I get up early in the morning.
I read
4 o'clock.
I read the preface to your book, and I got a kick out of the last paragraph where you mentioned that you said, I'm pleased to find my book frequently cited and generally followed by the courts at all levels. I have noted that judges and others not in the know tend to refer not to the author but to the editors. The reference to editors comes from the fact that a book of this size is likely to command a whole series of editors, and apparently they say they believe that maybe they're under the assumption that I am dead, and you write in it, but I remain alive and I remain the author.
Yes.
And you
you can see what they Yes.
And you remain a barrister to this day. How many years a barrister?
Yes,
and do you
I've
still
been a
appear?
barrister.
Do you still appear in court
still a
and try
barrister.
cases?
Yes, I don't appear in court very much now. The only case that I'm likely to appear in court is in India. I have a case in the Supreme Court of India, but they're very, very slow in India, and the case has been going on for years and still hasn't got to trial. But one day it might.
Now, are you licensed to practice in India?
Sorry?
Are you licensed to practice in India?
No, they would have to license me for the case.
Okay.
And the other side have objected to that, a foreigner coming in. But the court says, well, he is an expert in the field, knows much more about it than any of the Indian lawyers, and they would decide on whether they'd license me once the case came on. And the case still hasn't come on, so we're not sure. But they're fairly confident the court will allow me to address them on the damages issue. Because the damages issue is only one issue in the case. It's a big case, obviously, if it's in the Supreme Court.
Well, you must be consulted often. You must get phone calls all the time from barristers all over the country asking you about issues of damages.
I do get quite a lot, yes. But I was just going to go back so that your readers would know, or your listeners rather would know, that you read the last paragraph, which said that a book of this size, people would expect there'll be a lot of editors, which there generally are. I am unique in the fact that I write a book of this size alone, whereas the contract book has about 20 editors. But they might just want to know that the book is now 2,146 pages long, which is quite a sizable book.
Yeah, it is an amazing book, and I've had a chance to read through it. When we talk about damages, just for the people that are, let's say, suing somebody, we talk about different kinds of damages. Let's say if we're talking about an automobile accident or something like that, we have, in America, we have what we call general damages, and then we have special damages. That's how
we have the same.
And so our damages law, basically, it comes from the common law, from the English law. Where
Yes, it does.
What differences between the English law of damages and the American law of damages are you aware of, right off the top of your head?
Well, I think you can get quite a lot of what are called punitive or exemplary damages in the States. Isn't that right?
Yes. And they're not. Are they allowed in English law?
And only in a very limited way. And also, your exemplary damages, they're very high, aren't they?
Well, it depends on the case, but sometimes, and we have juries, and the jury can award exemplary damages, and many times we find that judges, after the jury award, may reduce that. The judge has the power to come in and reduce the punitive damage award. And it often is done when the jury awards too high an award of punitive damages.
What sort of size of awards do you find from juries?
It's going to run it's going to all depend on the size of the case. You could have
yes, that's right. But
you could have a jury award. You could have a jury award millions of dollars in punitive damages against the corporation. It's generally going to be based upon the amount or the ability of the defendant to pay the damages. It's kind of in the nature of it's going to be in the nature of if it's meant as a punishment. So if the defendant is very wealthy, a small award would not be much of a punishment. So it's got to be a large enough award so that it punishes them depending upon how much money they have.
Sure. Well, that's not dissimilar, but we would never go up to $1 million. The highest awards would never go beyond a few, 30, 40, 50,000. So we don't, and we only award exemplary damage. We used to award, we invented exemplary damages just the decade before the breakaway of the American colonies, which was in the 1770s. And our first exemplary damages case was in 1763. But since then, we've cut down on exemplary damages because the courts think they are anomalous in the sense that damages should be about compensation for loss and not punishment and punishment really is for the criminal courts rather than for the civil courts. But they didn't feel that they could change the law entirely, so they've kept one or two areas where, well, just two areas where you can get exemplary damages. One is if the defendant is seeking to make a profit out of his wrongdoing, and the other is claims against government servants who behave badly and maliciously. So that there's two very limited categories. I mean, you never get it for a car accident, for instance. However grossly negligent the defendant was. Can you get exemplary damage in the States for car accidents?
We have a statute here in Virginia which allows you to, if you have a blood alcohol content of over 0.15, then you can get punitive damages. It's actually by statute. If it's a drunk driver injuring somebody, they're going to find that that person was under the influence to such an extent that they should be punished, and you can get an award of exemplary damages for that.
And the money goes to the plaintiff.
And the money goes
to the state.
And the money goes to the plaintiff, and the lawyer gets a percentage of it as part of his fee. It's a contingency fee usually.
Yes. We don't have that.
I have a question about judges and juries. I noticed that the Oscar Pistorius verdict just came back. A lot of international news about that. And that was a judge that made that decision in a criminal case. Do you still have juries that try cases in criminal and civil matters? Is it still a jury system?
We have juries. We certainly have juries that try cases in criminal matters, but we don't have juries in civil matters. We've got juries, hardly any jury trials for damages cases.
And
it all started in the First World War. We had juries right up to the First World War in civil cases, and then it was very difficult to find men, because they only used men for juries at that stage, because it was the days before before suffragettes got their way and women's votes and the like came in. So since all the men, or not all the men, but a great number of the men had gone off to fight the war against Germany, it was very difficult to find juries. And so as a provisional decision, it was held that cases, civil cases, could be held by a judge alone, and that turned out to be so successful that after the war, it took a number of years, they effectively abolished juries from civil cases. They kept one or two cases which had emotional sides to them, for which the principal one is libel or defamation. But even that now, in this last year, they've decided that on the whole, there won't even be jury trials in defamation cases or in fraud cases. One of the reasons is with fraud in particular, juries find it very difficult to understand what these complicated frauds are, that you get in commercial life these days.
Well, we have juries
That answer your question?
we have juries that handle all sorts of complex securities litigation, and we have all kinds of.
And are they
and
are they good? Are they good at doing it?
Well, I guess that's the question. I know that it does take obviously the jurors and the judges and the lawyers are all very conscious of that, so they spend a lot of time explaining it to the jurors. But if it's a complicated case, you're going to have 12 people, or actually maybe less than that, on a civil case. But that's the system. I mean, you certainly have the right to the jury trial. It's part of the Constitution. It's in the United States Constitution, the Sixth Amendment, that you have the right to a jury
Yes.
trial for both civil and criminal cases. So you just can't take it away unless we amend the Constitution. So it's there. It's in.
Yes,
But
you see, we don't have a written constitution like you.
I am. But but in the criminal cases, you still have a jury. How many people serve on a criminal case?
Oh, generally 12. I mean, I think it's over 12. But they do have now majority verdicts. I mean, by majority, I don't mean 7. I mean 10.
10-2.
10-2, yes.
I have
Tell me, do you have majority verdicts?
It depends on the state. In Virginia, no. Where I'm in Virginia, it has to be unanimous. And in most states, it has to be unanimous verdict. I think there are some states where a majority is enough. I think in Texas, but I can't always speak to every single state. But here, it has to be unanimous.
And would that be a majority of as much as 10?
No, you have to have it unanimous. It has to be. There's 12 jurors in a criminal case. They all have to be.
No, I understand. But if you got to a state like you say Texas, where you've got a majority verdict will do, does the majority have to be as high as 10?
Yeah, I don't know. I don't know exactly what it has to be. I do know that I was on the phone with a. We were talking about criminal death penalty cases in Florida. Did you know that in Florida, you can have you have to have a unanimous verdict to convict somebody of a criminal case, a murder case, but on the death penalty part of it, you can actually have a majority rule, and they can rule in favor of the death penalty. A little scary. But
that's very scary, yes.
But does a judge? I have a question. I was talking with someone the other day, a barrister friend of mine, a local trial attorney friend, and he was talking about a jury trial that he'd seen in Old Bailey once, where a judge made a comment to the jury. It was a criminal case where the judge was able to sum up at the end of the case and made some comments to the jury. Are judges allowed in a criminal case to sum up and to kind of give the jury what that judge's opinion is of the evidence in the case?
No, he's certainly allowed to sum up, and he does sum up, but he doesn't have to give his own view. That's not permitted. Because if he gave his own view, that would be tantamount to saying to the jury, you better decide this way.
Maybe
So he's not allowed to. He's got to be impartial, but he certainly sums up. He wants to explain to them about the evidence and about the witnesses, and that is always done.
So the judge gets a chance to sum up, and he can sum up and basically tell the jury what the evidence is. Can't he kind of let them know what his opinion is of the case by how he sums up?
Well, not really. Sometimes there's by implication you might have an indication, but the answer is no to that. He's not supposed to, as I say, he's got to present the summing up entirely impartially.
And does and if he did something and it seemed partial, would that be rule?
Well, that could well be an appeal.
Okay, great. Now, have you ever tried?
May I say, none of this is about damages. So I'm not necessarily an expert.
I got it. But I thought that over the course of your career, you would you've been across just about everything. So I'm just covering all the bases. On this day,
I've done I've done one or two criminal cases when I was very young, but you tend to move into civil chambers. For instance, our chambers now, none of us, and there are over 40, none of us does any criminal work.
You have 40 barristers in your chambers there?
I think it's 46 now.
Now, the other
And
day...
some are bigger.
The other day when we were Skyping...
They've grown recently.
The other day when we were Skyping, you were in Edinburgh, correct?
I am still.
And you're in Scotland.
I'm in Scotland. I was going to do this in my chambers in London because I've been down in London. But by unlucky chance, they're changing the whole telephone system in chambers today, of all days, Saturday the 13th. And so the telephone is not functioning in my chambers. So I had to come back to Edinburgh in order to deal with the interview.
Well,
That's why I'm here and not in London.
Right. I know that we're about to have to go to a break again, Harvey, so I'm just going to do a quick 1 minute on this. Scotland's voting on its independence. You are in Scotland now, and there's a big vote on independence. Just a few days, isn't it?
Yes, and it's very neck and neck now.
And
had you read that?
Yes, I just read it. We talked about that the other day, and I've been following it. I saw another account on it in today's paper here, and so it's big news here and on this side of the Atlantic too. We're going to take a short break.
It's big news all over the world.
Yeah. We're going to take a short break here. We've just finished our first hour with Harvey McGregor. We're going to come back after these breaks, and we're going to talk more with Harvey McGregor, who is commander of the British Empire and Queen's Counsel, a super barrister from England, and we're looking forward to talking with him again after the break.
The reason why our country is in the trouble that it's in is because our pulpits have gone neutral. That is the job. Right now, our pulpits are so afraid to shine the light into true darkness, they won't do it. What do you say we put our pen lights down and we grab a spotlight and we start looking where real darkness is and we start putting light where darkness is?
Glenn Beck weekdays, 3 to 6 p.m. on K-Talk 1650.